Commercial Institute presenting shorthand dictation, legal and journal passages for upcoming SSC, PSC, Rail, High Court, District Courts exam at the rate of 80, 100, 120, 140, 160 and 200 words per minute. For acquiring 120 and 160 speed in a very short time, you should follow these guidelines. Practice this dictated passage 4 times at a stretch in a day. Practice each outline before taking dictation thoroughly, and transcribe and check your transcription from dictated passage which I dictated in this video.
Let's start. The learned Chief Judge, City Civil Court, by this order dated 6 April 1981, has dismissed the case under Section 30 of the Arbitration Act and also the appellant's application for temporary injunction inter alia, finding that the aforesaid recommendations of the Labour Commissioner West Bengal could not be taken as an award under the Arbitration Act, and the provisions of the Industrial Disputes Act would apply for enforcement of the said rights under the Industrial Dispute Act. Therefore, the court had no jurisdiction to entertain the said application under Section 30 of the Arbitration Act. Stop here. Being aggrieved thereby, the appellant union preferred this appeal. Mr. Mitra, learned advocate for the appellant, has submitted that the provisions of Arbitration Act applied to the aforesaid award of Sri S.K. Bhattacharya, Labour Commissioner, West Bengal, and therefore the City Civil Court had jurisdiction to entertain the appellant's application under Section 30 of the Arbitration Act for setting aside the said award inter alia on the ground that the arbitrator had misconducted himself. According to Mr. Mitra, the industrial disputes between the contractors of the aforesaid company and their workmen were settled in the manner set forth in the tripartite memorandum of settlement dated 29th July 1979. Stop there. The clause 5 within bracket small a within bracket small I of the said settlement did not provide for a voluntary reference of any dispute to arbitration under Section 10A of the Industrial Disputes Act, but the parties had agreed that in the event of failure of bipartite settlement, Sri S.K. Bhattacharya, Labour Commissioner, West Bengal, acting as a private arbitrator, would make a binding recommendation about the wages of price-rated workers. Mr. Mitra has submitted that the said arbitration in terms of paragraph 5 within bracket small a within bracket small I was not an arbitration under Section 10A or under any other provision of the Industrial Disputes Act. Therefore, the Arbitration Act would be applicable to the purported award given by Sri S.K. Bhattacharya, Labour Commissioner, West Bengal, Parachim. We note that the learned Chief Judge, City Civil Court, has rightly held that the appellant's application under Section 30 of the Arbitration Act was not maintainable in the first place. Undisputedly, the memorandum of settlement dated 25th July 1979 was recorded in course of a conciliation proceeding before the Deputy Labour Commissioner, West Bengal. The rates of wages of daily rated time rated workmen were settled under paragraph 5A within bracket small I of the said memorandum, but under paragraph 5A within bracket small I, the price rated workmen were given certain benefits as an interim measure on an ad hoc basis, and the said clause provided for further negotiations first on the bipartite level between the parties if the matter was not settled by such a bipartite negotiation. Same was to be taken up at tripartite level by the Labour Commissioner, West Bengal. Stop Parachim. The Labour Commissioner, West Bengal, after examining the present facts, circumstances and labour records, was to give his recommendations, which would be finally binding on all the parties. It is clear that the dispute regarding the rates of price-rated workmen was still to be finally settled in the manner set out above, and therefore the conciliation proceeding in respect of the said dispute was to continue. In other words, the parties to the aforesaid memorandum of settlement dated 25th July 1979 had only agreed about the manner in which a binding settlement between the parties regarding rates of price rated workmen would be thereafter arrived at para. The learned advocate appearing on behalf of the respondents have submitted that industrial dispute under Section 2K of the Industrial Disputes Act means any disputes or difference which is connected with the employment or non-employment or the terms of employment or with conditions of labor of any person. Therefore, the aforesaid dispute about rates of wages payable to price rated workers was clearly connected with the terms of employment of the workmen of the contractors of the company. Reference has been also made to Schedule 2, 3, and 4 of the Industrial Disputes Act. Obviously, no settlement was made by the bipartite negotiation contemplated by paragraph 5 within bracket small a within bracket small I of the aforesaid settlement dated 25th July 1979. Therefore, the explanation it would be taken up at tripartite level by the Labour Commissioner clearly contemplates a tripartite conciliation proceeding by the Labour Commissioner West Bengal. No doubt the said dispute about the wages of price-rated workers was agreed to be settled according to the recommendations of the Labour Commissioner. Such recommendation by the Labour Commissioner West Bengal was to be made in the course of conciliation proceedings. We are unable to agree that in making such recommendations, the Labour Commissioner had acted in a private capacity and not in discharge of his duties as a conciliation officer. Para. The aforesaid claim of the price-rated workers to obtain revision of these rates of remuneration was not made under the general or common law. The appellant union purporting to represent the said workmen did not allege that the employers had any contractual obligation to raise wages of their price-rated workers. According to the appellant union, as a result of collective bargaining, the aforesaid memorandum of settlement dated 25th July 1979 was signed in course of a conciliation proceeding. Under the Industrial Disputes Act, the Industrial Disputes Act itself contains elaborate provision for enforcement and adjudication of special rights and obligations under the said Act. Therefore, the remedy available to the workmen agreed by the impugned recommendations of the Labour Commissioner West Bengal as under the Industrial Dispute Act itself. For the foregoing reasons, we upheld the order of the trial court, rejection the application under Section 30 of the Arbitration Act filed by the appellants. Therefore, we do not express any opinion on the merits of the cases of the respective parties regarding the validity, legality, and the binding nature of the impugned recommendation made by Sri S.T. Bhattacharya, Labour Commissioner, West Bengal. The order passed in the present proceeding would be without prejudice to the rights and contention of the parties in any other proceeding according to law. We may only note that the respondents themselves had asked before us that a person or persons aggrieved by an award made under Section 10A of the Industrial Disputes Act in appropriate case may file writ proceedings or seek redress under the provisions of the Industrial Disputes Act itself. We are also not expressing any opinion as to whether or not a civil suit would lie in case it is alleged that the proceeding under the Industrial Disputes Act is void ab initio or without jurisdiction in view of the fact that the application under Section 30 of the Arbitration Act filed by the appellant was not maintainable. Their prayer for temporary injunction must also fail in limit. Stop. Para. Thank you. Jai Hind. Jai Mera Bharat.